title is Cryptocurrency Exchanges, a Reaction to Recent Developments, but I'm changing it. And the new title is What a Difference a Year Makes. For those who joined us last year, you may recognize Paul Graywall from Coinbase as being a repeat speaker for us. He's the Chief Legal Officer at Coinbase, where he's responsible for their legal compliance, intelligence, and government relations groups. Before he joined Coinbase, he was Vice President and Deputy General Counsel at Meta and served as U.S. Magistrate Judge for the U.S. District Court for the Northern District of California. Previously a partner at Howry and received his JD from the University of Chicago Law School and his bachelor's from MIT. So we're very happy to have you back with us, Paul.
Thank you for having me.
So I thought I would start this session trying to highlight some of the big developments that have happened since we had Paul here last year.
It has been quite a year.
It has been a year. And then we'll dig a bit deeper into some areas to get Paul's thoughts on the progress that has been made and what still needs to be done, in his opinion, to make the U.S. an attractive place to conduct crypto business. And as always, Paul can interject at any time and ask me questions if he has any. But let's get started with what has happened since last year. So,
Let's do it.
when you were here last year, we were just a few weeks out from the election. Crypto supporters had organized and put their money behind pro-crypto candidates, including President Trump, in the hopes of prompting change in our country's crypto policies. At that point, the stakes were really high for crypto and Coinbase in particular. We did not have majority support for stablecoin or market structure legislation at that time. We had an SEC administration that we've discussed today that the industry viewed, I think, as hostile to crypto generally and allergic to regulatory updates specifically. We discussed the SEC's rejection of Coinbase's petition for rulemaking, not to mention the litigation that the SEC had initiated against almost all of the country's leading crypto platforms, including Coinbase. But a few weeks after the conference, we had an election, and well, everything changed. Crypto won, I think, pretty fantastically. I'm not sure whether every candidate that crypto backed won or not. Maybe I bet Paul does know. But it certainly won the biggest and most important race in its eyes by helping President Trump secure his return to the White House. From that point forward, I'm going to try to mark down. I'm going to take through these really quickly, but what I see is the biggest developments on the crypto front. We'll start with Trump. On the campaign trail, he made it clear that crypto would be one of his top priorities. In July of 2024, during the Bitcoin conference, he promised that if he were elected, he would fire Gary Gensler, stockpile Bitcoin to hedge inflation, end Operation Choke Point 2.0, something I hope Paul will explain to us later, and guarantee U.S. domination of the crypto markets moving forward. The next big thing to happen on the crypto front after the election was that Biden's SEC chair, Gary Gensler, announced that he would resign on January 20th. The crypto industry was pretty happy to see that. Trump might not have been, because it denied him the pleasure of delivering his campaign pledge to fire Gensler. But Trump takes the office in January and issues an executive order his very first week. And he proclaims the U.S. will be the crypto capital on the planet. He revokes Biden-era executive orders and creates the president's working group on digital asset markets. He gives the SEC and CFTC 60 days to come up with a plan to remediate rules and guidance that are harmful for crypto, and 6 months for the working group to hatch legislative and regulatory solutions, including a digital asset stockpile or reserve, to help achieve his goal of U.S. crypto dominancy. President Trump appointed Commissioner Mark Uyeda as acting SEC chair, and interim chair Uyeda wasted no time in moving the White House agenda forward. On the same day he is appointed, on January 20th, he immediately created the SEC's crypto task force and appointed his fellow commissioner, Hester Peirce, the task force chair. An excellent pick, right? I think everyone here can agree with that. Trump announced that Paul Atkins would be the new SEC chair, and that appointment was later confirmed in April. The SEC Crypto Task Force does not wait for Atkins to come in. They take DC by storm by hosting their spring sprint to meet the demands outlined in the executive order, focusing on key policy issues. If you've not checked those out, they do have recordings of those, and you can they're topical, they're really great. You do hear from leaders on each of those topics, so I highly recommend that. They were also doing road shows across the country, but the government shutdown has kind of put a little damper on that. Today would have been one of the road shows here in Cleveland, but we still have Commissioner Purse, and for that we're grateful. The SEC's Division of Corp Fin, meanwhile, starts issuing guidance that's viewed by many as accommodating to the crypto market. I won't spend time reviewing those. You can also look all of those up on the SEC website. By February, the SEC is dropping crypto lawsuits right and left, or at least tries to wherever it can, and even tries to release some crypto players that I think had agreed to settlement terms that the commission now had regretted. At this point, things start heating up on the legislative front. On May 21st, Senator Hagerty introduced stablecoin legislation known as the Genius Act, and it passed the Senate in less than 1 month on June 17th. This law requires stablecoin issuers that peg cryptocurrencies to stable currencies like the US dollar to maintain a one-to-one reserve. 1 month later, on July 17th, the Genius Act passes the House, and the House passes its version of market structure legislation known as the Clarity Act. Trump signs the Genius Act the following day. As you can tell, things are moving very, very quickly after not moving very quickly for a long, long time. A group of senators on the Banking Committee, including Ohio's own Senator Moreno, circulates a discussion draft of their market structure bill in July, captioned the Responsible Financial Innovation Act. We'll refer to it as the RFIA. On July 30th, the White House issues a comprehensive 166-page crypto report. Another thing that I would encourage you to look at if you're really wanting to dig into crypto. Senators on the Banking Committee privately circulated a revised version of the RFIA on September 5th. The SEC and CFTC hosted a joint roundtable just about 1 month ago, and GOP leadership in Senate banking, as we heard earlier today, were originally going to have a markup of that bill this week, but the shutdown has stalled all of that. So that, I think...
Other than that, what happened?
catches us up from Paul's visit last year. So really no regulation or structure for 15 years and then everything all at once. So let's get into some of these specific topics. First, I'm going to start with the new and improved SEC. So one of the biggest changes, we've chatted with you last year, is just the change at the SEC, and we've described it as a full 180, the SEC being hailed as crypto villain to perhaps the crypto darling of federal financial regulators. So, and you know, Coinbase has, whether friend, foe, or indifferent, has been at the door all along the way. And so, how is it going? What is Coinbase's interactions with the SEC now? How are things going? Give us the update 2025 version.
Well, certainly compared to 2024, 2023, and 2022, it's going pretty well. And I say that only partially tongue-in-cheek. There's no question about it that it is a new day in Washington, and I would certainly commend the SEC as having led a real change, not just in direction, but tone towards this technology and towards this asset class. What was, I think, perhaps the most dark period for the industry just a short while ago has really, I think, blossomed into something much more promising, not just for our own success, but we think for the success of this new opportunity for millions and millions of Americans investing in cryptocurrency every day. What I would say in terms of our interactions with the SEC, as things stand today, is the shutdown has posed some challenge. Commissioner Purse alluded to that earlier. In asking a question of her, I also referenced the fact that I think staff is enduring admirably during this period, but it has impacted just a lot of the mechanics of how we are able to pursue exemptive relief, no action letters, and the like. But the progress does continue. I would say even before we get to the question of our engagement and others' engagement with the commission, the fact of the matter is, as your chronology underscored, Andrea, we have seen just an entirely different approach to engagements that preceded even the formal appointment of Chairman Atkins. I think it is remarkable, for example, that we now have a team, not a team of rivals, but a team of kindred souls and leaders at the commission operating in lockstep with one another, at least to the outside. Of course, Commissioner Peirce and others could speak to whether that's always the case inside the building, but certainly in presenting to the outside community a perspective, for example, on the virtue or value of guidance on meme coins or the desirability of tokenized equities, whatever the topic may be, it is just so refreshing and frankly productive to see the commission acting with one voice and in lockstep. We have certainly seen, I think, important guidance provided by staff even before getting to the question of no action relief on a number of topics. And again, settling many issues which should not be controversial on their face. For example, we were talking earlier about meme coins and their status as securities. It's a bit remarkable that it required guidance from staff in order to settle that question here in the United States in 2025. And yet it was necessary given some of the uncertainties created under the previous administration. On no action relief, I'm quite encouraged that we're starting to see already progress and benefits from the Crypto Task Force and the work of the staff as a whole on topics, for example, about the ability of investment advisors, for example, to rely upon state chartered qualified custodians. Very useful, very productive guidance and leadership demonstrated there. And I think on a whole host of topics we're going to see, hopefully with the shutdown soon behind us, even more progress in that engagement with not just the industry, but critics of the industry and everyone who has a stake in the future of this asset class.
Yeah, I think that's an important point. Definitely a new day at the SEC, but they post on their website. There's a lot of transparency. It's not just a love fest over there. I'm sure Commissioner Peirce and the task force, have their fair share of naysayers and people and critics who want to come in and share their views. So that's all part of the constructive process.
As they should.
Right, to get to yes, because last administration, it's a different group of people. So yes, definitely important to have that constructive, iterative process. So I'm going to tick through a couple of the staff statements and just because I feel like you and I are you're definitely more into the weeds than probably anyone else besides Commissioner Peirce here. But a lot of people are hearing these staff statements and are probably not familiar. So I'll go through them just quickly. The SEC did kind of go into the crypto guidance area on the issue of meme coins. I would say for a lot of those coins, like people would not be surprised that the SEC does not believe something called Farcoin is a security. People are not necessarily investing in that. But there are other meme coins, and we talked about this during the prep session, like Dogecoin, that control a significant part of the crypto, market, and some people do, I believe, invest in that coin, that token, as what they view to be an investment grade asset. Certainly was my son and all of his college friends, foray into crypto was investing in Doge and probably for fun, but I found out about it because he's like, Mom, I made some money in the market. And I'm like, what do you mean you made some money in the market? Well, I made some money on Dogecoin. I'm like, oh, well, that's great. Let's sit down and talk about investing. Right? But I think that what the SEC was trying to do there was say, no, let's what is not a security? We can at least start with the things that, and kind of signal to the world things that we think are not securities. And they did start with meme coins back in February. In March and May, they issued guidance indicating that crypto mining and staking are not securities transactions. We had a lot of good conversation about that today, so I won't go into that. In April, the staff issued guidance on the offering and registration of securities in the cryptos markets. I think this bit of guidance was intended really as helpful guidance to token issuers in the ICO context. If you are doing something that does feel more like a security, then here are some disclosure frameworks that you might use in order to engage in that a little, more transparently, building off of the work that Commissioner Peirce and others had taken on Reg X and trying to figure out what would be good disclosure frameworks. In August, the staff issued guidance on staking in the lending context. Their staff signaled its view that those activities are not generally regarded as securities transactions, even though that is not something, that was not the opinion that the SEC had with respect to Coinbase and obviously was related to the Coinbase litigation. So at a high level, I think this guidance has been well received by the crypto industry as a good faith effort by the SEC to right the ship, kind of, so to speak. But at the end of the day, staff guidance is not the same thing as an SEC rule. Staff guidance is informal and non-binding and can be withdrawn via a new statement at any point down the road. So that's really the trick here. But I do think the SEC, as Commissioner Persh explained, is not, we are waiting to see what the Congress does. It's really hard to, implement rules and adopt rules without knowing what the code looks like. So, Paul, Congress is moving fast. Both it and the SEC have a lot on their plate. SEC rulemaking by itself takes time. And here we need the SEC to coordinate with the CFTC, who I would say is not moving as quickly as the SEC. Do you think the SEC will be able to get its new positions codified into rule before the end of the Trump administration?
Well, there's a lot there to unpack. Let me speak, if I may, first and foremost to the question of coordination with the CFTC, which I do think has significant implications for the question you posed, which is speed and how quickly the commission can act. I don't know in my professional lifetime that we've seen cooperation to the degree and at the level that we have seen between the SEC and the CFTC as we have seen in the last several months. It is remarkable. We are now seeing joint roundtables. We are seeing, I think, a preview of what I believe will be the state of the world once we see legislation enacted that really does knit and stitch together these separate regimes and these separate oversight bodies for the very first time. And so that has me quite optimistic that while there will always be bumps in the road and challenges in managing two agencies with two sets of leaders and frankly two governing statutes and the like, that what we will see less of is a lot of the confusion or uncertainty, and in some cases even turf battles that I think have plagued this space for some time. I do think that the commission has a tall order in front of it in that even before we get to the question of what they will do with the new legislation, there's still a lot of work that is underway and already in process that needs to be finished in order for, I think, the full scope of protections for investors and the full elimination of the uncertainty created under the previous administration to be addressed. I'm confident we're going to get there. I do think it will be a lot of work. And one of the things I encourage others in the industry, many of whom are in this room or listening to us remotely today, to remember is that if we are so fortunate as to see legislation passed and signed this year on market structure the way that we did on stable coins, that is not the end of the regulatory process. That is the beginning of the regulatory process. And so there will be years of work that lie ahead for the commission and for all of us interested in these issues to get the details right. So that's one thing I think is very important to bear in mind. The other thing I would share is that I think that one underappreciated cost or impact of the current shutdown on the legislative process is the capacity of the regulatory agencies to provide technical assistance to members of the Senate at present as they go about the work of trying to nail down the details of the pending market structure bill and hopefully get something passed this year for the president to sign before the new year starts. Technical assistance matters, and I think, frankly, much of what we suffered, if I can use that word, over the last several years reflected in part a lack of support for a legislative process from the regulatory agencies that may have been in part by design, but regardless of why it happened, really impacted, I think, the ability of Congress to legislate effectively. So that's a long way of saying I think we have a lot of work that lies ahead, and I think both commissions have a lot of work that lies ahead, but I think if we think about it for a moment, it's all the more reason for us to see legislation passed this year, not next year or beyond.
Yeah, but it is important for them to get it right, and I agree, technical assistance is really important. In the Clarity Act, you had this unusual thing where, most tokens were not securities, but they treated as federally covered securities. So you got, it helps to have those experts at the SEC come in and opine and point out some of those issues when you have non-securities, non-lawyers drafting.
Absolutely.
In Congress, we need our subject matter experts on call. So we're going to talk now about litigation. One of the most controversial lawsuits that the SEC filed during the Gensler administration was the lawsuit against Coinbase. It was controversial for many reasons, but for me personally, the two biggest reasons were, one, the SEC well understood Coinbase's business model because the SEC had registered Coinbase as a public company for years, and if the SEC thought the business model was unlawful, we would have expected it to act on that sooner. And then the biggest problem, I think, in a lot of people's views, is that Coinbase had approached the SEC for guidance and rulemaking on how to conduct its crypto transactions, and the SEC refused to provide it. So that was, obviously a bitter pill to swallow. But the SEC was not alone in that lawsuit. Some big states joined the SEC in the Coinbase lawsuit. Some big states like Ohio, Texas, and Florida did not. After the election, most states dismissed their actions this year in tandem with the SEC's dismissal, but not all states. And one new state, Oregon, filed a belated Me Too action against Coinbase, alleging the same causes of action. So where is the state litigation now?
Well, unfortunately, we continue to face intense state litigation, even though the matter with the SEC was resolved. What began as a handful of states that have focused on our staking product or service has now been supplemented with a separate case brought, as you mentioned, Andrew, by the state of Oregon that essentially reads, almost to the degree of a cut and paste job of the complaint that was originally filed against us by the SEC in 23. Those cases are going to work their way through the courts if they are not resolved sooner. I would point out that none of them has yet proceeded to any substantive adjudication, and so they are still all relatively early. For example, in the Oregon case, we are still wrangling with the state over whether it belongs in a federal court or whether it should be remanded to state court. So there's a lot of early procedure that's still working its way there. And the fact is that depending upon how Congress ultimately decides to act, there could be preemptive effect that would, I think, materially impact the shape of those cases, but time will tell on that. I think the real, tragedy from our perspective of the ongoing state cases is that it really does continue to cast a cloud over not just our business, but the industry as a whole on a very important product and service, staking, most specifically. But that it impacts tens of millions of Americans who, in those states, who have been denied access to these.
So that's how you guys deal with it. So the states that have litigation pending, their citizens.
We comply with cease and desist orders issued by a duly appointed state securities commissioner. That should not be a shocker, but it does mean that you've got hundreds of millions of dollars in rewards, for example, that are available to citizens of 40-some states across the country, not available to the 4 or 5 states that have chosen to continue with this litigation.
So that litigation and the SEC litigation has been characterized as a regulation by enforcement approach. We talked about that a little bit earlier during Commissioner Peirce's segment. So from some company that experienced that firsthand, what is the lesson that the SEC and really all regulators should learn and take away from that experience, because it's costly not just for the companies that are on the receiving end, but the SEC has spent had a lot of resources that were not deployed to other purposes and wasted resources and cost unwinding that approach. So what are the lessons?
Well, the costs are certainly massive and quite real. I would say first and foremost, the most important lesson is one we were reminded of earlier in Commissioner Peirce's remarks. It should be a basic norm or notion of due process that before you are accused of breaking a rule, you are told what the rule is. That was really the simplest way to understand our efforts early on in our engagement with the Commission, to come in and have a good faith conversation about how these relatively arcane, or at least relatively old, ancient laws apply to modern and indeed cutting edge or bleeding edge technologies. It doesn't mean the laws aren't important. It doesn't mean the laws aren't to be respected, but there are good faith disagreements about how to take this 3 or 4, we can't even agree on the number of factors under Howey, let alone how to apply it to distributed networks that are predicated on blockchains. So I do think that hopefully we've moved beyond this gotcha mindset and much more towards let's talk about the rules are, and then let's hold people accountable to them. And I will say that many of us in the industry are the loudest champions of aggressive enforcement, because there's nothing more painful or miserable for me in advising my client. I have one client, which is the Coinbase Global Incorporated Corporation, about how to comply with the law when we see others choosing not to. And so that discrepancy is really something that the good actors in the industry care as much or more about as anything else. The second maybe lesson I would underscore from the experience is that every dollar that was spent on this misguided campaign against not just my company but many others in the industry over the last 3.5 years was a dollar that was not directed towards combating the fraud, scams, and abuses. We just spent an entire half day or more walking through some terrible examples of how real people get hurt by criminals out there who are preying upon the innocent and taking advantage of gaps in our enforcement system. Well, how do we generally address these gaps when we confront them in the law? We spend money on hiring investigators and hiring regulators and hiring prosecutors to go after these people wherever we can. Everything that was dedicated towards the effort to go after legitimate actors in the industry over the last 3.5 or 4 years took resources from those efforts and left those people that we just saw up on the screen and talked about vulnerable. That's wrong. That's real harm. And while no one may ever cry a river over a large public corporation's litigation budget and what we had to spend in order to defend ourselves, I also think about some of those people who we talked about earlier today, who are still suffering the trauma and effects of what they were subjected to. I think that a proper allocation of resources, even if it couldn't have eliminated that, could have certainly addressed it or mitigated it in a meaningful way.
Yeah, we talked about this last year. I mean, Coinbase has been one of our strongest partners in terms of our investigations, because we can't really do the tracing and find the people without working with the exchanges. And so when you do have an exchange like Coinbase cooperating with you, we've been able to hold people accountable. We've been able to deliver restitution to people because of that cooperation. But you heard during Tim's session that not all exchanges are created equally. Not all of them are going to cooperate. Not all of them collect the necessary KYC information in order to. And so the absence of regulation, it's not even just the money, the commitment of resources. It's just the failure to collect the information that we need in this regulatory regime that Coinbase urged the SEC to implement as part of its rulemaking petition really has helped facilitate fraudsters, mostly overseas, from stealing from Americans for sure. So now, I know this is a securities conference, Seth, and we don't normally talk about the CFTC, but since we're talking about crypto, I think we'll have to do that. So the way that I understand it, there are many tokens that are used for utility, other tokens that have the attributes of a commodity, but in our enforcement division, we see tokens of all varieties being sold for investment purposes or just used as the currency of choice in scams, because it is the easiest way for those thieves overseas to steal from our Americans and our Ohioans. So I still believe today, sitting here today, that the securities regime is the best regime for regulating those transactions. And that the only way to really fight those crypto scams is to have the whole regulatory community, federal and state, working together. Because that's where the retail regulatory apparatus and those resources sit. But we know that there is legislation, market structure legislation, that is being considered that would seek to preempt state registration requirements, which I'm not opposed to. You heard us earlier today say that we support a NISMIA framework, which is a preemption framework for dealing with those digital asset securities. But most of the tokens and most of the transactions, as I read the RFIA or the Clarity Act, are going to fall to the CFTC. And so that gives me pause. That's not really what I would like to see, but that may not be your view, Paul. Last year when we talked about it, I think you were championing the CFTC as being the appropriate regulator, especially for those secondary market transactions, which is where most of the work would be happening. So that's, I think Congress agrees with you based on what I'm seeing. They want to shift a lot of those transactions over to the CFTC. Is that what Coinbase still wants today?
Well, I do think a significant role for the CFTC continues to make good sense, and I think that's largely because that's how Congress has chosen to, in its wisdom, regulate this space over the last 70 or 80 years. I think it would be a grave mistake for us to run roughshod over the dividing line between securities and non-securities transactions, no matter how good faith our motivation or reason for doing so, and including where our interest is entirely in keeping people safe. The good news is I think there's a way to address the safety issue without trampling that line. I happen to think that the Clarity Act and the RFIA both achieve that in large part. It's not exactly the statute I might have drafted if I had the pen, but I think it accomplishes much of the goal. And it does it in a couple of important ways. One, it very much recognizes that tokens which are in fact securities will remain, and hopefully will forever be subject to the jurisdiction of the Securities and Exchange Commission. And I actually think one interesting open question in the industry is the extent to which we actually, with this legislation in place, are more likely to see more tokens openly promoted and therefore subject to regulation by the Securities and Exchange Commission because they are in fact securities. That's one thing I think that's important to bear in mind. The other is that under the Clarity Act, and I think under the RFIA as it ultimately will pass, you're going to see an extension of the securities regime and the jurisdiction of the SEC beyond the tokens which, strictly speaking, meet the Howey test and qualify as securities. And I'm referring now to the ancillary assets, which are the subject of many investment contract transactions that have been used to distribute these tokens over the years. So while the specific disclosure regime applicable to ancillary assets will look different than the regime applicable to securities tokens, the fact of the matter is, in that very real, tangible sense, you're going to see the expansion of SEC powers, not the restriction of them. That, by the way, is not a topic that is without controversy within the crypto community. We have had some fairly tough conversations internally in the industry about the wisdom of that approach and its implications for our continued growth. But that is where Congress has landed in the House, and I think will land in the Senate. And I do think that's an important part of the regime to continue to recognize. Now, CFTC. There's no question the CFTC will take on a very significant role in regulating, for lack of a better way to put it, most or all of everything else that falls within the digital asset space. And that will be a very different role from its historic practice. And I think will require very different resources as well. I understand and frankly share many of the concerns about the CFTC's technical competency and resourcing to address these issues. But I would point out that the solution to that is not simply to, I think, dismiss the CFTC as an effective regulator, but instead to ask what are the resources it needs to actually do the job. Because again, I sit literally before this audience as the chief legal officer of a publicly listed S&P 500 company that has been begging for regulation and trying to register all over Washington and all over the world for many years now. We have no interest in allowing people to use the CFTC as a get-out-of-jail-free card. All that does, candidly, is hurt our business and make it harder for me to explain why I need to hire another 300 compliance analysts in order to review transactions on our platform or file more SARs or whatever else we need to do in order to be in full compliance with the BSA and other regimes. So I do think it's important for us to acknowledge that the CFTC needs to be ready to take on this role, and that's going to require additional resourcing to be sure, and it will be a different muscle than it has exercised historically, recognize all of that. I think it is more than capable of meeting that challenge, and I think that it will do so as part of a regime that is a partnership with the SEC as opposed to a relationship at which they are at swords end with one another. And that's going to be something that we're all going to have to get a little bit more used to than maybe those of us who have grown up under a more traditional division of labor. And I think it's also just a better way to think about the market as a whole, because the fact is, digital assets do migrate status over time as they become more decentralized, as they evolve and mature over time, as groups which may have an outsized influence in their direction and operation at the earliest stages of the project play a much less significant role at later stages. I think it's only logical that we would treat them differently, and that perhaps we would call upon different resources across the federal government to keep investors and purchasers safe as a result.
I like your optimism.
I try to be optimistic. I'm from Ohio. I have to be optimistic.
I like it.
I'm a Cleveland Browns fan. I have no choice.
So I won't pick on the CFTC issue anymore. You know, I am concerned about resources and just the regulatory apparatus, but I hear what you're saying, and I do appreciate that in the Clarity Act and the RFIA, they do recognize that these tokens, albeit a commodity, at the token level, can be sold in an investment contract, and that is where the security regulators, like the Division of Securities, have interest. And
well,
so,
I also want to recognize that, sitting in your seat, which I have never done, I can only imagine. It's hard when you get these phone calls or these visits from people, who've been really hurt. And, again, hearkening back to some examples we were talking about earlier today, regular folks don't care about whether something's a security or commodity or who has your station. They just know they've been ripped off. We need to address that head on.
and resources, I guess I am going to get back on the bandwagon just a minute. Resources are really important.
They are.
The people who call us say, we called the SEC, we called the CFTC, we called the Department of Justice, we called the FBI, we called the local police department. We're not getting our calls returned. And it's not because those agencies don't care. We are overwhelmed. We are all working together. We are pedaling as a team as fast as we can to deal with these issues. And it really does take all boots on the ground in order to do it. So when we look at the draft of the Clarity Act and the RFIA, from our perspective, we're very much looking at, are you taking away the authority we need to do our jobs? Because we're going to continue to get those calls. And federal resources, though, Coinbase he's on record supporting the CFTC, getting the resources it needs to do its job. It's not the kind of path that the federal government is going. It's not growing federal government right now. At least that's not what I'm seeing. And so we're going to continue to get those calls. And if these bills pass and we can't rely on investment contract analysis, or we're preempted in a way that's going to make these cases cost prohibitive to us, then we need place to refer those to. So I'll let that go, but I do appreciate your optimism. We got to start somewhere, for crying out loud. I mean, it's been 15 years, we got nothing. We have to start somewhere. So I am very encouraged and optimistic about that. Let's shift now to banking regulators, something else that we don't normally talk about at the Securities Conference. But there's something known as Operation Choke Point 2.0. And I really don't know much about this other than, I read the headlines, and what I read is kind of discouraging. But I know you know about this, and Coinbase has been actively involved and vocal about this issue. So tell us a little bit, what is, for those who don't know, Operation Choke Point 2.0 or even 1.0?
Well, Operation Choke Point 1.0 was an actual project under previous administrations to deny basic banking services to certain disfavored industries without actually acting under legislative authority. So these industries tend to be, for example, in the firearms or legalized marijuana space, for example. So the label Operation Choke Point 2.0 came to be applied to a less formal but no less targeted effort under the Biden administration to refuse permission or authority to regulated banks to provide products and services to the crypto industry, or to offer support to crypto firms that were looking for basic banking services. It will come as no surprise to folks that crypto businesses, like any other, need a checking account or credit or other basic forms of financial service. And in many instances, regulators, particularly at the FDIC, but not exclusively at the FDIC, were committed to denying their banks the authority or permission to provide those services and issue what were called pause letters. Now, why did we care about this? Coinbase, fortunately, was never denied any particular services, but many of our business partners were. And in many instances, I had individual employees who reported to me telling me that they were being denied the opportunity to get a refinanced home loan or a new mortgage on a new townhouse or whatever, simply because when they reported who they worked for, suddenly the trail went cold. I ultimately authorized the company to file suit against the FDIC to get under FOIA to get access to the documents that would prove this, and it was no small challenge. Any of you who've done any FOIA litigation know that is not something that is a one and done exercise. It is iterative, over and over again you go, but eventually we got documents out which proved that without any legislative authority and after denying that this exercise had taken place, in fact, pause letters were issued, and without any legislative authority, legal American businesses were denied banking services simply because they were engaged in a business that was out of favor with the administration's priorities. Now, you may love crypto, you may hate crypto, you may think something in between, but as people who are responsible for interpreting and applying the law to businesses and industries of all types, as I suspect many of us in this room are, it should give you great pause to learn that your government, my government, our government, was in certain instances exerting pressure outside of normal channels and without a specific authorization from Congress to deny those banking services simply because the industry that those businesses were engaged in were not a priority. That, if it could happen to crypto today, it could happen to anyone tomorrow. And that's why, Andrea, we felt it was so important, even though it was not directly implicating our business, that we shine as bright a light as we could on the practice. And that's what took me to Congress to testify on the subject. That's what led to, I think, a firm commitment from the new head of the FDIC as well as other banking regulators to get to the bottom of this. And we're seeing real progress in just the last several months.
So we're in a good place now?
We're in a better place now. Yes, we're in a better place.
In a better place. All right. We'll shift away from banking. Let's see. I did want to turn back to investment contract analysis.
Actual securities, okay.
Yeah, back to securities. Just a minute. I kind of shared what my perspective is. I mean, if you've gone to this conference for years, and I know a lot of you have, our enforcement briefings every year, the worst of the worst cases, the criminal cases, the Ponzi schemes, the pyramid scheme cases, are cases we bring in reliance on investment contract analysis, every one of those cases. And if it gets tinkered with and messed up, we can't not only bring, the crypto fraud cases and provide recovery in those cases, we may be shut down and just traditional finance, traditional scams in the Ponzi scheme front. So we're going to guard that jealously. We're going to fight like hell to avoid that from happening. But within, it's not clear to me, what is happening with the federal legislation. I think there's conflicting language there. So where does Coinbase stand on investment contract analysis? Should this be dealt with in the market structure bill? Does the SEC really need to redefine the investment contract tests after Congress has laid down the law on what is and is not a security in the digital asset marketplace?
Well, I think that regardless of what I would characterize, using a technical term, the shenanigans of the previous regime and bending and twisting the Howey test in order to sweep in many transactions which plainly were not securities transactions, it's important to recognize, for all the reasons you suggest, that Howey is settled law, and it is settled law that has largely served the public interest. So I stand separate and apart from some in our industry and many others who want to just throw out Howey entirely and start over. First of all, I think it would take an act of Congress to do that, and I don't see.
Well, as a matter of fact.
But I don't think you see anything in either the Clarity Act or the RFIA or any serious proposals regarding either to eliminate investment contracts from the jurisdiction of the federal securities regulators, or to somehow legislatively rewrite the standards as applied to all forms of investments as opposed to those that are specifically digital assets. So that's point number one. My other point on this is that I do think that it is important, particularly when we pass legislation, to understand that individuals, companies, and yes, regulators, we need clarity, hence the name of the act, as to what it is we're dealing with, so that we aren't relying upon enforcement actions and lawsuits and courts in order to protect this market or these markets. And so I think that it would be a mistake to think that somehow any of us are well served by distortions and abuses of these four factors under Howey in order to address one problem without acknowledging it creates all sorts of other problems that are only going to grow bigger with time. So that's a long way of saying that I think Howey continues to be good law. I think it largely serves a strong purpose outside of crypto. And I think that the legislation will address some of the messy details inside of crypto that have, I think, put Howey at greater risk than it should have been.
I hope Congress kind of stays out of the investment contract interpretation business. I mean, if they want to have the SEC do some rulemaking where the subject matter expertise exists, I'd feel more comfortable with that. When I see mandates, it is a little concerning to me, but we shall see what happens with that. Section 105 definitely seeks to tinker with and mandate that the SEC view certain things and Howey differently. Which, again, if it interferes with our ability to shut down criminals in the state of Ohio, we definitely would take issue with that. So we only have a few minutes left. I'm sure there are some questions here, but I'll give you one more.
Sure.
So, Paul, what are, looking ahead, what are your or Coinbase's priorities looking ahead? Are there anything, certain things that absolutely must happen in your mind before the end of the Trump administration? Or any other thoughts you want to share before we take some questions?
Well, shocker. I think we need to pass the RFIA and get it signed ASAP. That would be one. I would say that there are a couple of other priorities at the federal level that I think are important in order for us to finish the job. One is we got to get crypto tax policy right. I think the broader public has yet to appreciate how complicated and messy the tax issues as applied to digital assets currently are and will remain unless we address some of this through legislation. I would also suggest that the Bank Secrecy Act has led to many forms of distortion and even abuse that could and should be corrected through further legislation, at least as applied to crypto. So I would hold out hope that we would turn to that as soon as we get past market structure. And then at the state level, if I can just put a plug in for good state legislation, I've been very encouraged that a number of states have adopted amendments to their unclaimed property laws that have recognized that crypto and digital assets should be treated no better, no worse than any other forms of unclaimed property, and in particular should not be liquidated at the point of seizure by the state in a way that denies account holders or property owners of the value of that appreciation once they make their claim. So we're seeing good progress there, and we want to see that continue.
All that I have for you. I will cut into a little of my closing time to make sure that the audience here has some time for questions. Does anyone have any questions for Paul?
So, Paul, first of all, thank you again. I repeat what I said to the commissioner, that your generosity for being here, I just appreciate it so much.
My pleasure.
We get into the time machine. We go 15 years in the future. What does 15 years, from now look like in crypto? And also, now that we're in the future, you look back. What does 2025 mean? Is it a bump in the road? Is it a landmark year? How would you look at it?
Well, it's hard to predict 15 months out in crypto, let alone 15 years. What I would hope, though, if I look into that crystal ball for a moment, is that frankly, we no longer have conferences on crypto, like this one, that it will have become so boring and uninteresting and too far behind.
You don't want to come back.
I want to come back. I never say no to you. You know that. But you know, the fact is, I do think, you know, the real objective here. This is not just about cool stuff or doing something different. We want to make lives better, and we want to improve our system. And so my hope, John, is that we get to a point in 15 years where the financial system relies upon open networks and permissionless networks in ways that are uninteresting and settled. So that would be my real hope. As for what we will think about 2025, because I am optimistic that we're going to see market structure legislation pass, if not by the end of this year, early in 26, I think we're going to look at 25 and 26 in the way that securities lawyers and law students look at 33 and 34. They're going to be hollowed years, hollowed numbers in the canon if we do this right. And that's what has me most excited and optimistic about that work.
Very well be true if it's worked out right, which means no tinkering with investment contract analysis, limited Disney-style preemption. Other people have questions for Paul? Yes.
What about crypto in 401k? Does that bring up opportunities, concerns, new sets of regulations?
That's a very good question. So for those listening, the question was, what about crypto and 401ks? Look, I do think that it can make good sense for people to have some portion of their retirement portfolio in crypto. I don't give investment advice, but again, in this always. But I do think that, you know, again, it's important to proceed cautiously and thoughtfully in that regard. All the more reason for us to get the legal questions around digital asset status resolved first before I think we see that open up in any major way.
And it's why we have licensed professionals called investment
That's
advisors and broker dealers who are really good people to talk to before you start playing with your 401k and your retirement securities, right? We do have licensed professionals who can help you figure that out and help you make informed, safe decisions. Other questions for Paul? Mark.
With respect to the unclaimed property issue, are you aware of any reliable study you could refer us to, given the relative volatility of that asset class, on whether or not holding would be preferable to liquidation?
I don't know the study specifically, so unfortunately I can't provide that. What I can say is that you know, as legislation has been proposed and adopted in a number of states, the focus has been to treat this asset class no differently, no worse than any other subject to the unclaimed property laws. And in some cases, in many cases, you know, the volatility of other assets which are subject to those laws is also substantial. So, you know, I can understand the appeal of wanting to liquidate and not put either the individual or the state at some risk from that volatility. But I suspect if a study has been done, if it's been looking at the last 10 or 15 years, on balance, you know, most people will have suffered significant losses relative to a decision to liquidate as opposed to, you know, having been protected in some way.
And it can cut the other way too. I mean, in the enforcement and the fraud space, you know, there's this preference for fiat conversion, and in some cases, by the time they get paid out, the bad actors happy to pay off, you know, at the fiat rate and walk away with some, you know, nice chunk of Bitcoin to spare, making the cost of business pretty attractive. And so we have to figure out better ways. We don't want to victimize people twice. Once, you know, not having their money returned to them when they needed it, and secondly, some unhelpful loss due to some fiat conversion or liquidation when they would just rather have their cryptocurrency, I think. All right, Seth?
One more.
Yeah.
Paul, you recently released sort of a proposal for a potential overhaul of the BSA. In particular, I'd also note Commissioner Peirce recently gave a wonderful speech that involved three of my favorite topics: peanut butter, watermelon, and privacy. Can you just sort of outline the high points of your BSA proposal for the audience?
Yeah. Unfortunately, I can't make references to fruit or peanut butter as eloquently. Look, I think to take a half a step back, what is the Bank Secrecy Act for those who don't live with this issue every day? It fundamentally imposes a regime on financial intermediaries to serve as an extension of law enforcement and agencies in government charged with keeping people safe by requiring, for example, strict rules around understanding who your customers are and what they are doing on your platform, and then perhaps most critically, reporting suspicious activity where and when you see it. So that's the high level for those of you less familiar with the statute. All good principles, and at least I think in concept. What unfortunately has transpired since the bank secrecy was passed almost 50 years ago, roughly 50 years ago, right? Is it early 70s? Am I right about that?
1970.
Okay, plus 50 plus then. Says something about my age.
Mine too.
But unfortunately, what's happened, given the explosion in data and explosion of online activity and the explosion of reliance upon third-party intermediaries, we now have a dragnet of surveillance that I think would give most Americans at least pause, if not make them blush outright, if they really understood how much of their information was subject to this oversight, surveillance, and in many cases, production to the government. So I think that while there are some who have raised constitutional questions around this deputization of third-party intermediaries, and I think there's some interesting legal doctrines to wrestle with, should someone choose to pursue those claims all the way to the Supreme Court, for example. I think in the meantime, there are I think, some basic pragmatic, practical steps we can take as a system and as a country to at least shrink or mitigate the effects of those standards as applied to a modern internet-connected world. First and foremost among them, and this is really the one reform I would highlight from our paper, there are now technical means to confirm identity, and this is something in the industry we refer to as a zero-knowledge proof, a ZKP, and that's as technical as I'm going to go on that, that effectively allow an individual to confirm his or her identity without having to provide to a bank all the information about who they are, where they live, what their social security number is, how many children they have, what their income is, in ways that are relatively unhelpful to the purpose of collecting the data, but obviously create a huge honeypot and a very attractive surface area of attack for people who can put that information to work in unhelpful ways, in criminal ways. So we really think it would be helpful for FinCEN and for the Treasury Department and for the government as a whole to appreciate that there are not technical means that can achieve the same end with far less loss of personal privacy, and that they should be recognized, or at the very least encouraged and developed and nurtured inside of a sandbox or other tests and trials that will prove the concept.
Paul, we have run out of time, but let's hear it for Paul Graywald. Some final housekeeping here. First, I'd like to recognize all of our excellent speakers today, our co-sponsor and host, Case Western Reserve School of Law, and my team, who, again, I know that goes by quickly, but there is so much work. We start literally the week, a couple weeks after this, we start prepping for the next week. So I want to start with David Beamel. I don't know where, there he is. Jeff Coleman. Ballard. Because we couldn't do this without their support. So thank you to everyone on my team. And then outside, you met Ray Glenn and Jen Coit. Thank them as well for helping with registration. So my last little bits are, please remember to fill out the survey that you will receive next week, especially if you're wanting continuing education credit. You'll need to fill out that form. You can ignore the form that you received earlier. And we'll make sure we're the ones that will submit your hours to the Supreme Court or your other credentialing organization. So with that, I think we can close out today. Thank you all for joining us in Cleveland. Hope to see you again next year. Thank you.